The bailiff called our case number like it was just another file in an endless stack, but Victoria Harrington stood before the last syllable faded. Not out of respect for the process. Out of confidence she'd already won. She wore a cream blazer over charcoal, quiet elegance that whispered credibility. Her posture was perfect. Her expression was controlled. And when she glanced toward the boy sitting beside me, there was no flicker of 8 years' worth of longing. Just the cool assessment of someone reclaiming property. This is a story about what happens when love is tested in a courtroom, and when documentation speaks louder than DNA. If you believe that showing up every day matters more than showing up when it's convenient, subscribe, like, share, and hit that notification bell. Justice doesn't always look the way we expect. Her attorney walked to the front with the ease of someone who'd choreographed this moment. Expensive watch, soft-spoken authority, a folder held like evidence of righteousness. Your Honors, he said, my client, the biological mother of Oliver Harrington, age 8, is petitioning for full custody. She has established financial security, emotional stability, and is ready to fulfill her maternal role. Victoria nodded with just enough humility to seem sincere. If you hadn't been there the day she signed herself out of motherhood, you might believe this was a woman who'd been waiting for the right moment to return. It wasn't. Behind her sat her parents, my former in-laws, faces arranged in supportive solemnity. They looked like a united front, like people who'd come to witness a daughter's restoration, not a grandson's potential displacement. The presiding judge glanced down at his notes, then looked at me. Mr. Harrington, he said. Do you contest this petition? Victoria's eyes met mine across the courtroom, and in them I saw the same assumption I'd seen 8 years ago, that I would eventually step aside, that biology would trump everything, that courts don't reward single fathers who do the work. Yes, Your Honor, I said. I contest it. Her lawyer's expression suggested he'd anticipated this. On what grounds, Mr. Harrington? The mother is present, willing, and legally entitled to parental consideration. I'm not challenging her legal standing, I said. I'm asking the court to consider the complete record. The second judge spoke up. Mr. Harrington, we see no documentation of parental rights termination. That weighs significantly in these proceedings. Victoria's shoulders relaxed slightly, she recognized the sound of momentum shifting her direction. I kept my voice steady. Then I asked for a brief delay before the court rules. The word hung awkwardly in the formal air. To what end? The presiding judge asked. To allow the final report to be submitted, I said. Victoria's attorney moved quickly. Your Honors, there is no outstanding report. My client's early absence was due to youth and circumstance, not intent. She stands ready to parent. Victoria added, voice soft with practiced regret, I was lost then. I've found my way back. The judges looked at each other, human beings responding to a narrative of growth and second chances. We're prepared to proceed, the presiding judge said. I didn't panic. I didn't plead. I simply said, 5 minutes. That's all I'm requesting. A pause. The judge sighed. 5 minutes, Mr. Harrington. No more. Victoria's composure flickered, just a shadow of doubt crossing her features. The courtroom doors opened with quiet authority. A woman in a charcoal suit entered, carrying a folder that seemed to carry more weight than its physical form. She approached the clerk with the deliberate calm of institutional purpose. Margaret Collins, she said. Child Welfare Services. Victoria sat up straighter. The folder was passed to the judges. When the presiding judge opened it, his reading pace changed from procedural to analytical. This is a longitudinal child welfare report, he said, surprise coloring his professional tone. Compiled over 8 years, Ms. Collins confirmed. Victoria's attorney stood. Your Honors, we object to undisclosed. Sit down, counsel, the judge said quietly. I want to understand what we're looking at first. He read further. This documents the entirety of the child's custodial history, caregiver consistency, medical oversight, educational engagement, and contact attempts by absent parties. Victoria's voice cracked slightly. I tried to reach out. He made it impossible. Ms. Collins responded with the steady authority of documented truth. Our findings do not support that claim. The judge looked up. Be specific. And that's when the room learned the difference between words and records, between claiming to care and proving you showed up. The judges didn't know it yet, but that folder contained something more powerful than legal arguments. It contained every single day Victoria chose not to be a mother, and every single day I chose to be a father. It all started in a hospital room 8 years earlier, when Victoria looked at our newborn son and said 5 words that would define everything that followed: I'm not ready to be a mother. She didn't cry when she said it. Didn't apologize. She just sat on the edge of the hospital bed, already dressed in the clothes she'd arrived in, staring at the discharge papers like they were a contract she regretted signing. Oliver was 6 hours old, asleep in the bassinet beside me. I'd been awake for 31 hours straight, running on adrenaline and the kind of joy that makes exhaustion irrelevant. I thought we were about to begin our lives together as a family. We weren't. I can't do this, Victoria said quietly, her voice steady in a way that told me she'd already made her decision before the delivery room. I thought I could, but I can't. She signed the hospital forms with a hand that didn't shake. No forwarding address. No emergency contact update. Just her signature releasing herself from medical responsibility, and by extension, from us. You'll be fine, she said as she stood. Not to comfort me. To convince herself. She left before the sun came up. I watched her walk down the hospital corridor, cream coat, designer bag, heels clicking with purpose, and disappear into an elevator without looking back. Oliver woke up 20 minutes later, hungry and crying, and I realized I didn't know how to make a bottle the right temperature. The early days were a blur of sleepless nights and Google searches at 3 a.m. How to soothe colic. How to read a fever. How to fill out daycare forms when there's only one parent's signature line and you don't know where the other parent is. I learned to function on 4 hours of sleep. I learned to prep bottles one-handed while holding a crying infant. I learned that financial strain isn't just about money, it's about choosing between hiring help you can't afford and admitting you're drowning. But I also learned something else: I couldn't afford to be bitter. Every 6 months, I sent Victoria a letter through her parents' address. Short, factual updates. Oliver's milestones. His daycare name. My current phone number. I offered mediation. I offered supervised visitation. I offered anything that would give Oliver the chance to know his mother if she ever changed her mind. The letters went unanswered. I filed annual affidavits with Child Welfare Services, documenting my attempts at contact. I kept copies of every letter, every returned piece of mail, every unanswered message. I updated my address with the court system every time I moved. Not because I was trying to build a legal case. Because I was trying to build a record of good faith, proof that I never closed the door, even when it would have been easier to. I wasn't raising a child for myself. I was preserving a record for the day someone might question whether I'd done right by him. That day had arrived. Back in the courtroom, the presiding judge turned another page of the report, his expression shifting from procedural attention to something heavier. Ms. Collins stood perfectly still, waiting for the questions she knew were coming. Victoria's attorney shuffled papers, searching for an angle that no longer existed. And Oliver's hand remained in mine, small, trusting, unaware that his entire future was being decided by people reading about the past 8 years of his life in clinical, documented detail. The second judge looked up from the folder and spoke directly to Ms. Collins. This report indicates the father made repeated, documented attempts at reunification, he said slowly. How many attempts are we talking about? Ms. Collins didn't hesitate. 16 formal communications over 8 years, Your Honor. All logged. All unanswered. Victoria's face went pale. The judges weren't undecided anymore. They were beginning to understand exactly what kind of case this was. The second judge set down the welfare report and leaned back, his expression shifting from analytical to deliberative. I recognized that look. It was the face of someone weighing law against circumstance, procedure against humanity. Mr. Harrington, he said carefully, while we appreciate the documentation, we must also consider the legal framework governing parental rights. Victoria's attorney stood immediately, sensing an opening. Your Honors, he said, voice measured and reasonable, the law recognizes biological bonds as foundational. My client made mistakes in her youth, mistakes she acknowledges openly. But rehabilitation is a cornerstone of family law. We don't punish parents forever for temporary lapses in judgment. Victoria nodded, her face arranged in practiced contrition. I was 23, she said softly, her voice carrying just enough tremor to sound genuine. I was terrified. I thought walking away was the right choice because I wasn't ready. But I've spent 8 years becoming the person Oliver deserves. It was a good performance. Believable. The kind of narrative that fit neatly into the legal system's preference for redemption over complexity. The presiding judge looked at me. Mr. Harrington, the court recognizes your consistent care. But absent formal termination of parental rights or evidence of unfitness, the law creates symmetry between parents. The mother has equal standing. Equal standing. The words landed like a gavel I hadn't heard fall. Victoria's attorney pressed forward. Your Honors, we're not disputing that Mr. Harrington has been a devoted father. But devotion born from abandonment doesn't erase biological rights. My client has demonstrated stability, she has a home, employment, support systems. She's asking for what the law already grants her, the right to parent her child. He glanced at me briefly, and in that glance was an implication I couldn't refute without sounding defensive. That I was emotional. That I was clinging. That my objection wasn't about Oliver's welfare but about my own wounded pride. I felt Oliver shift beside me, his small body pressing closer. He didn't understand the legal language, but he understood tension. His eyes moved between the judges and his mother, trying to make sense of why strangers were deciding where he would live. My chest tightened. I had done everything right. Every doctor's appointment, every parent-teacher conference, every fever in the middle of the night. I had documentation, consistency, 8 years of proof that I'd shown up. And it might not matter. Because the law favored the appearance of rehabilitation over the reality of abandonment. It favored biological symmetry over the asymmetry of effort. It favored a mother who looked the part over a father who'd lived it. Victoria's attorney continued, his tone almost sympathetic now. Mr. Harrington clearly loves his son. But love doesn't grant him the authority to deny a mother her legal rights simply because she made a difficult choice at a difficult time. The presiding judge nodded slowly, his pen hovering over the ruling sheet. The court is prepared to issue a decision, he said. We find that both parents have standing, and that a reunification plan. Your Honor, I said quietly, but firmly enough to stop him mid-sentence. The judge paused, pen still suspended. Victoria's expression shifted, just a flicker of irritation breaking through her controlled facade. Yes, Mr. Harrington, the judge asked, his tone suggesting his patience was finite. I kept my voice calm, even though my pulse was hammering. Before the court rules, I respectfully ask that the final report be entered into the record in its entirety. The second judge frowned. We've reviewed the welfare documentation, Mr. Harrington. Not all of it, I said. There's a second section. Victoria's attorney stepped forward quickly. Your Honors, this is a delay tactic. We've been more than patient. I'm not delaying, I said, meeting the judge's eyes. I'm asking you to see the complete picture before you create a reunification plan for a woman who already refused reunification 16 times. Silence settled over the courtroom. Victoria's hands, folded neatly in her lap, tightened almost imperceptibly. The presiding judge looked at Ms. Collins, who had remained standing near the clerk's desk, silent and composed. "Ms. Collins," he said. "Is there additional documentation?" She nodded once. "Yes, Your Honor. A sworn statement and communication logs." The judge's expression hardened slightly. He looked at Victoria's attorney, then back at me. "Please allow the final report to be entered," I said calmly. The room held its breath. The courtroom didn't move. Not visibly. But the air changed, thickened with the kind of tension that comes when everyone knows something is about to shift, but no one knows which direction it will go. The presiding judge glanced at the clock on the wall, then back at me. "We'll hear what you have to present, Mr. Harrington." Briefly. Victoria's attorney started to object, but the judge raised a hand. "Counsel, you've had your say. Let's see what this is." The clerk made a note. The court reporter's fingers paused over the keys. Even the bailiff, who'd probably seen 1,000 custody hearings blur together, straightened slightly in his chair. Victoria sat perfectly still, but I noticed the way her jaw tightened. The way her eyes flicked toward her attorney, then toward the door, then back to the judges. Her polished confidence was beginning to show hairline cracks. Her attorney leaned toward her, voice low enough that I couldn't hear the words, but I could read the body language. He was pressing her. Asking questions she clearly hadn't anticipated. She shook her head once, sharply, a gesture that said I don't know or this wasn't supposed to happen. I'd learned something in 8 years of single parenthood that most people never have to learn: patience is more powerful than protest. Screaming into the void doesn't change outcomes. Showing up quietly, consistently, with proof, that's what moves mountains. Or in this case, courtrooms. So I waited. Oliver shifted in his seat beside me, his small hand finding mine again. I squeezed gently, a silent reassurance I wasn't sure I believed myself. But children don't need certainty from their parents. They need presence. And I'd built 8 years on that principle. The second stretched. Victoria's mother leaned forward from the gallery, whispering something to Victoria's father. Their expressions had shifted from supportive certainty to something closer to concern. They'd come here expecting a formality, a judge's signature on a reunification plan, a photo opportunity for the family they wanted to project. They hadn't expected resistance with documentation. Victoria uncrossed and recrossed her legs, the first visible sign of discomfort. Her attorney kept his expression neutral, but his pen tapped once against his legal pad, a small tell that suggested he was recalculating his strategy. The courtroom doors at the side entrance opened. No dramatic swing. No announcement. Just a quiet, controlled push. A woman stepped inside. Mid-40s, charcoal gray suit that looked government-issued rather than tailored, sensible shoes, dark hair pulled into a functional bun. She carried a leather portfolio under one arm and walked with the kind of measured certainty that comes from institutional authority, not personal agenda. She didn't look at me. Didn't look at Victoria. She walked directly to the clerk's desk and presented her identification badge with the efficiency of someone who'd done this exact thing hundreds of times. The clerk examined the badge, nodded, and glanced toward the judges. The woman spoke clearly, her voice carrying no emotion, no inflection. Just information. Margaret Collins, Child Welfare Services. I'm here regarding case number 2026, FC 4471, Harrington custody matter. The room went completely still. Victoria's face drained of color, not dramatically, but enough that I noticed. Her attorney's pen stopped tapping. Her mother's whisper cut off mid-sentence. Ms. Collins opened her portfolio and removed a sealed folder. Official stamp across the closure. Date marked. Signatures visible even from where I sat. She handed it to the clerk, who passed it to the judges. The presiding judge took the folder carefully, almost reverently, the way someone handles a document they know will matter. He broke the seal and opened it slowly. His eyes moved across the first page. Once. Twice. Then he looked up at Ms. Collins with an expression I couldn't quite read, surprise, maybe, or recognition that this case had just become something more than routine. He turned to the second judge, showed him the document heading, and I watched the second judge's eyebrows rise slightly. The presiding judge cleared his throat and looked directly at Victoria. "This," he said slowly, "is a longitudinal child welfare report." Victoria's hands clenched in her lap. Her attorney stood. "Your Honors." "Sit," the judge said quietly. "I haven't finished reading." The presiding judge turned the first page, then the second, his reading pace deliberate. The courtroom stayed silent except for the faint rustle of paper and the quiet hum of the ventilation system. "This report," he said finally, looking up at Ms. Collins, "documents primary caregiver designation from birth to present." "Correct, Your Honor," Ms. Collins replied. Her voice carried no judgment, no advocacy. Just institutional precision. The judge continued reading aloud, translating bureaucratic language into plain fact. "It shows uninterrupted medical consent authority held by the father. Immunization records, well-child visits, emergency room authorizations, all signed by Mr. Harrington." He turned another page. "Educational enrollment forms. Parent-teacher conferences. School emergency contacts." He paused. "All listing the father as primary. The mother's contact information is marked as unavailable for the first 4 years, then unresponsive for the following 4. Victoria shifted in her seat, her composure beginning to fracture visibly. The second judge leaned forward, scanning his copy of the report. "Ms. Collins, this indicates the father filed updated location affidavits annually." "Yes, Your Honor," Ms. Collins confirmed. "Every year for 8 years. Each affidavit included current address, phone number, and a formal invitation for contact or mediation." The presiding judge looked at Victoria directly. "Ms. Harrington, were you aware of these affidavits?" Victoria's voice came out sharper than she probably intended. "I was never given access. He made it impossible for me to." "That's not accurate," Ms. Collins interrupted calmly. "No heat, no accusation. Just correction." The judge's eyes narrowed. "Explain." Ms. Collins opened her portfolio and removed a stapled packet. Each affidavit was sent to the last known address provided by Ms. Harrington at the time of the child's birth, her parents' residence. Delivery confirmation is documented for all 16 communications. She handed the packet to the clerk, who passed it to the judges. 16 communications, the presiding judge repeated, examining the delivery receipts. "Over 8 years." "Correct," Ms. Collins said. "Letters, mediation offers, and updated contact information. All sent. None returned as undeliverable." Victoria's attorney stood quickly. "Your Honors, my client may not have received these personally. They were sent to her permanent address of record," Ms. Collins said evenly. "The same address she used for tax filings and voter registration during the same period." The second judge flipped through the timestamps. His expression had shifted from neutral to something harder. Victoria tried again, voice rising with defensive urgency. "I sent things too. I sent gifts. Birthday cards. 3 packages," Ms. Collins said, consulting her notes. "Over 8 years." The judge looked up. 3. "Yes, Your Honor. The first arrived when the child was 2 years old. The second when he was 4. The third when he was 6. She paused, and that pause carried more weight than any dramatic revelation could have. "All 3 packages," she continued, "were addressed incorrectly. Wrong apartment number on the first. Wrong street name on the second. Wrong zip code on the third." The presiding judge's mouth pressed into a thin line. "None," Ms. Collins added, "contained return address information or contact details for the sender." Victoria's face flushed. "I didn't know the exact address." The father's current address was provided to your parents' residence annually, Ms. Collins said. The same residence you listed as your permanent address. The same residence where the affidavits were delivered. The courtroom felt smaller suddenly. Quieter. Victoria's attorney tried to pivot. Your Honors, intent matters here. My client clearly made attempts. 3 incorrectly addressed packages in 8 years, the judge said flatly, compared to 16 documented, confirmed communications from the father. He set the delivery receipts aside and looked at Victoria with something close to disappointment. Ms. Harrington, he said, this doesn't read like obstruction. This reads like avoidance. Victoria opened her mouth to respond, but no words came. The second judge spoke, his tone colder now. Ms. Collins, does this report contain anything else we should review? Ms. Collins nodded once, her expression unchanging. Yes, Your Honor, she said. There is also a sworn statement. Victoria's eyes widened. Her attorney stiffened visibly. And I felt Oliver's hand tighten around mine as the courtroom held its breath. Ms. Collins reached into her portfolio one final time and withdrew a single sheet of paper, sealed in a plastic protective sleeve. She held it with the same institutional calm she'd maintained throughout, but the judge's attention sharpened instantly. This is a sworn statement, Ms. Collins said, signed by Ms. Victoria Harrington 6 years ago, witnessed and notarized, filed with Child Welfare Services as part of a routine inquiry. Victoria's face went pale. Not the subtle pallor from earlier, this was immediate, visible shock. I don't, she started, her voice cracking. That was taken out of context. The presiding judge raised his hand. Ms. Harrington, I haven't read it yet. Ms. Collins handed the document to the clerk. The protective sleeve crinkled slightly as it was passed to the bench. The presiding judge removed the paper carefully, his eyes scanning the header first, official letterhead, date stamp, notary seal. Then he began to read silently. The courtroom waited. Victoria's breathing became audible, shallow, quick. Her attorney leaned toward her, whispering urgently, but she shook her head repeatedly, her composure completely shattered. Her mother made a small sound from the gallery, something between a gasp and a protest. The presiding judge looked up slowly, his expression no longer neutral. It had shifted to something grave. Ms. Harrington, he said quietly, did you provide a statement to Child Welfare Services in March of 2020? Victoria's voice came out thin. I was under stress. I didn't mean. Did you provide this statement? The judge repeated, his tone firmer. Yes, she whispered. But. The judge cut her off gently but decisively. I'm going to read this into the record. Victoria's hands gripped the edge of the table, knuckles white. The judge read slowly, clearly, giving each word its full weight. I, Victoria Harrington, am making this statement voluntarily and of sound mind. I was contacted by Child Welfare Services regarding my son, Oliver Harrington, born June 14, 2018. I am confirming that I do not wish to pursue custody or visitation at this time or in the foreseeable future. I do not want contact with the child. I do not want updates about the child. I am choosing to live my life without parental obligation. The silence that followed was absolute. No rustling. No whispers. Nothing. Just the devastating weight of Victoria's own words, spoken 6 years ago, now echoing in the courtroom where she was demanding full custody. The second judge leaned forward. Ms. Harrington, you signed this statement under oath? I was young, Victoria said desperately, her voice rising. I was confused. I didn't know what I was saying. You were 25, the judge said flatly. And the statement is notarized. Victoria's attorney stood, trying to salvage something. Your Honors, people change. Growth is possible. My client's past statement doesn't negate her current readiness. Counsel, the presiding judge said, his voice cold now, your client didn't just walk away. She formalized her abandonment in writing. Under oath. And she did so not in a moment of crisis, but 2 years after the child's birth. He held up the statement. "This isn't confusion," he said. "This is clarity." She explicitly rejected parental obligation. Victoria's face crumpled. "I made a mistake." "You made a choice," the second judge said. "A documented, notarized, legally binding choice." The presiding judge turned to me. His expression softened slightly. "Mr. Harrington," he said. "You've remained silent through most of these proceedings." "Yes, Your Honor," I said calmly. "You've raised this child alone since birth." "Yes." "You've never denied lawful access to the mother." "Never, Your Honor." The judge nodded slowly, then looked back at Victoria. "Ms. Harrington, the law does allow for rehabilitation. But it requires sustained effort, demonstrated change, and, most importantly, consistency." He tapped the sworn statement once. "You showed no effort for 6 years after making this statement. You sent 3 incorrectly addressed packages. You ignored 16 documented attempts at contact. And you appeared in this courtroom today asking for immediate full custody." Victoria opened her mouth, but nothing came out. The judge continued. "Consistency, Ms. Harrington, is what the court values. Not intention. Not regret. Consistency." He glanced at the second judge, who nodded. "We're going to take a brief recess," the presiding judge said. 10 minutes. The gavel came down with a sharp crack that made Oliver flinch. Victoria sat frozen as the judges rose and exited through the side door. Her attorney gathered his papers with shaking hands. And I sat perfectly still, Oliver's hand in mine, knowing that the next 10 minutes would determine everything. The courtroom emptied quickly during the recess. Victoria and her attorney disappeared into the hallway, her parents trailing behind with expressions caught between anger and confusion. Ms. Collins remained near the clerk's desk, reviewing her notes with professional detachment. I stayed in my seat. So did Oliver. For a moment, we just sat there in the too-quiet room, his small hand still wrapped around mine. I could feel the tension in his grip, not fear exactly, but the uncertainty children carry when they sense the adults around them are deciding something important. "Dad?" His voice was so quiet I almost didn't hear it. I turned to look at him. 8 years old, dark hair that never stayed combed no matter how much I tried, eyes that looked too serious for a kid who should have been thinking about playground games and what was for dinner. "Yeah, buddy." He hesitated, his gaze dropping to our joined hands. "Am I going to have to go live with her?" The question hit me harder than any legal argument could have. Because it wasn't about parental rights or documentation or sworn statements. It was about a child trying to understand why his world might be about to change. I took a breath, choosing my words carefully. I'd never lied to Oliver, never made promises I couldn't keep. I wasn't going to start now. "I don't know yet," I said honestly. "The judges are deciding right now." "But I don't want to," he said, his voice cracking slightly. "I don't even know her." "I know." "Why does she want me now?" he asked, looking up at me with confusion that broke my heart. "She didn't want me before." How do you explain adult complexity to a child? How do you make sense of abandonment and redemption narratives and legal standing when all he understands is that his mother left and now wants him back? "Sometimes," I said slowly, "people make choices they regret. And sometimes they try to fix those choices later." "But you've always been here," Oliver said, his grip tightening. "You've always been my dad." "And I always will be," I said firmly. "That much I could promise. No matter what happens in this courtroom, I'm your father. That doesn't change." He nodded, but I could see the fear still lingering in his eyes. I thought about what custody really meant in this moment. Not the legal definition. Not the arguments about biology versus effort. But what it meant to this child sitting beside me. Custody meant knowing that when he came home from school, I'd be there. It meant predictability, the same bedtime routine, the same terrible dad jokes, the same person who knew he hated mushrooms and loved dinosaurs and needed his nightlight on to fall asleep. It meant presence. Not perfect presence, because I'd made plenty of mistakes over 8 years. But consistent presence. The kind that builds trust brick by brick, day by day, until a child knows in his bones that he's not alone. That's what was at stake here. Not a legal battle between two adults, but a child's entire sense of security. "Oliver," I said quietly, "whatever the judges decide, I need you to know something." He looked at me, waiting. "You are the best thing that ever happened to me," I said. "Every single day with you has been worth it. Every sleepless night, every worry, every moment, all of it. You understand?" His eyes filled with tears, but he nodded. "I love you," I said. "I love you too, Dad." We sat there in the silent courtroom, two people holding onto each other while strangers decided their future. Then the side door opened. The bailiff stepped out first, followed by the clerk. "All rise," the bailiff said. The judges were returning. Oliver's hand squeezed mine so tightly it hurt, and I squeezed back just as hard as we stood together and waited to hear the words that would define the rest of our lives. The judges entered with the same measured formality they'd had all morning, but something had shifted in their bearing. They weren't performing neutrality anymore. They'd made a decision, and they carried it with the weight of institutional authority meeting moral clarity. Everyone stood. Victoria returned to her seat, face carefully composed but eyes betraying tension. Her attorney straightened his papers needlessly. Her parents sat rigid in the gallery. I felt Oliver pressed against my side, his breathing shallow. "Please be seated," the presiding judge said. The courtroom settled into silence. The judge looked down at his notes briefly, then raised his eyes to meet the room with steady gravity. "This court has reviewed the petition for custody transfer, the welfare report, the communication logs, and the sworn statement provided by Child Welfare Services," he began. "We've heard arguments from both parties. And we've considered the legal framework governing parental rights and the best interests of the child." He paused, letting the weight of the moment settle. "The law does recognize biological bonds," he continued. "It does allow for rehabilitation. It does create pathways for parents to re-establish relationships after absence." Victoria's shoulders relaxed slightly, a flicker of hope crossing her features. "But," the judge said, and that single word landed like a gavel, "those pathways require evidence of sustained effort, demonstrated commitment, and most critically, consideration of the child's established stability." The hope in Victoria's expression began to fade. "Ms. Harrington voluntarily abandoned custodial responsibility at birth," the judge said, his voice firm and clear. "She formalized that abandonment in a sworn statement 6 years ago, explicitly rejecting parental obligation. She made no documented attempt to establish contact despite 16 formal communications from the custodial parent over 8 years." He looked directly at Victoria. "This is not a case of a parent being denied access," he said. "This is a case of a parent choosing absence, then claiming urgency only when confronted with the legal and emotional consequences of that choice." Victoria's face went very still. The presiding judge glanced at his colleague, who nodded once, then turned his attention back to the courtroom. "It is the ruling of this court," he said, "that primary legal and physical custody of Oliver Harrington will remain with his father, Marcus Harrington." Oliver's breath caught. His hand squeezed mine so tightly I felt his pulse hammering against my palm. "Furthermore," the judge continued, "this court finds that Ms. Victoria Harrington voluntarily abandoned parental responsibility and demonstrated no meaningful effort toward reunification until the filing of this petition." Victoria's attorney started to stand, but the judge raised a hand. "I'm not finished, counsel." The attorney sat. "Any future petition for custody modification or visitation rights," the judge said, "will require Ms. Harrington to complete a graduated reunification plan supervised by Child Welfare Services. This plan must demonstrate sustained, child-centered engagement over a minimum period of 12 months before any unsupervised contact will be considered. The second judge spoke for the first time since returning. To be clear, Ms. Harrington, this is not a denial of your biological relationship to the child. This is a protection of the child's established stability and emotional well-being. Victoria didn't cry. She didn't protest. She just sat there, hands folded in her lap, staring at nothing. The performance was over. The confident, reformed mother who'd walked into this courtroom expecting validation had been replaced by someone finally understanding that good intentions declared today couldn't erase 8 years of documented absence. Her attorney gathered his papers quietly, the shuffle of documents the only sound in the room. The presiding judge's expression softened slightly as he looked at Oliver, then at me. "Mr. Harrington," he said, "this court commends you for your consistency, your documentation, and your willingness to keep the door open despite receiving nothing in return. You've demonstrated what true parental commitment looks like." I nodded, not trusting my voice. Oliver leaned against me, and I felt the tension draining from his small body. The judge picked up his gavel, then paused. "There's one more thing," he said, his voice taking on a tone that suggested he was speaking not just as a judge, but as someone who'd seen too many cases like this. "Something this court wants to make abundantly clear." Victoria looked up, her eyes meeting the judge's for the first time since the ruling. The courtroom held its breath, waiting for whatever final statement would close this chapter. The judge set down his gavel but didn't strike it yet. His eyes moved between Victoria and me, then settled on Oliver with an expression that seemed less judicial and more human. "Courts measure what can be documented," he said quietly. "Affidavits. Statements. Delivery receipts. Medical records. We measure these things because the law requires evidence, not emotion." He paused, and the courtroom remained absolutely still. "But there are things courts cannot measure," he continued. "We cannot measure the value of a parent who shows up at 3 a.m. when a child has a fever. We cannot measure the consistency of a bedtime routine, or the trust built through 8 years of uninterrupted presence. We cannot measure what it means to a child to know, without question, that someone will always be there." His gaze shifted to Victoria. "Ms. Harrington, biology creates a child," he said. "But consistency raises one. This court hopes that you will come to understand that distinction." He lifted the gavel and brought it down with finality. "This matter is concluded." The hallway outside the courtroom was quieter than I expected. No dramatic exits, no shouted arguments. Just people dispersing back into their separate lives. I stood near the window at the end of the corridor, Oliver's hand still in mine, watching the parking lot below. Victoria emerged from the building first, her cream blazer stark against the gray pavement. Her parents flanked her briefly, but there was distance between them now, physical space that reflected something broken. Her attorney said something I couldn't hear. She nodded once, not looking at him. Then she walked to her car alone, got in, and drove away without looking back at the building. She'd arrived expecting validation and left with the truth she'd spent 8 years avoiding, that abandonment has consequences, and that motherhood isn't a title you claim when convenient, it's a role you earn through presence. I didn't feel triumph watching her leave. I felt something closer to sadness for what could have been if she'd made different choices. But mostly, I felt relief. Oliver tugged on my sleeve. "Dad?" "Yeah, buddy. Can we go home now?" Home. The small apartment with the dinosaur posters on his bedroom wall and the kitchen where we ate breakfast together every morning and the couch where we watched movies on Friday nights. Home, where he'd always known he belonged. "Yeah," I said, my voice thick. "We can go home." We walked to the car together, his backpack bouncing against his shoulders. He didn't ask about Victoria. Didn't ask when he might see her again. He just asked if we could stop for ice cream on the way home, and whether we could finish the puzzle we'd started last weekend. Normal questions. Safe questions. The questions of a child who knew his world wasn't going to shift beneath him. As I buckled him into his seat, I thought about the judge's final words. Courts measure what can be documented. But parenting happens in the spaces between documentation. It happens in the goodnight kisses and the packed lunches and the homework help and the scraped knees and the quiet moments when a child learns they matter simply because they exist. I'd spent 8 years building that foundation, one ordinary day at a time. Victoria had spent 8 years building a life without it. The court had measured what it could measure, affidavits, timestamps, sworn statements. But what really decided this case was simpler and more profound than any legal document. I'd shown up. Every single day. And Oliver had known, in the way children know these things without needing to be told, that I always would. That night, after Oliver had brushed his teeth and climbed into bed, after I'd read him 2 chapters of his current favorite book and turned on his nightlight, he looked up at me with those serious eyes. Dad? Yeah. I'm glad I get to stay with you. My throat tightened. Me too, buddy. Will she come back? I thought about lying, about protecting him from complexity. But I'd built our relationship on honesty. Maybe someday, I said. If she does the work the judge talked about. But that's not something you need to worry about right now. He nodded, satisfied with that answer, and closed his eyes. I sat there for a moment longer, watching him drift toward sleep, and understood with complete clarity what the judge had meant. Biology had given me a son. But consistency, showing up through fevers and nightmares, through first days of school and scraped knees, through ordinary Tuesday evenings and extraordinary courtroom mornings, had made me his father. That was the lesson Victoria had learned too late. And it was the truth that would guide everything that came after. I turned off the bedroom light, leaving only the soft glow of the nightlight, and walked quietly to the door. Behind me, Oliver's breathing had already deepened into the peaceful rhythm of sleep. The sleep of a child who knew he was home.